Hello landlords, it's Ernie. I'm back. And today we're talking about repairs again. Do you like paying double? If not, you're going to want to watch. Let's get started. This is going to be one of a number of landlord lessons that I'm going to present of things you just really shouldn't do in an eviction proceeding or when you're dealing with your tenants in a landlord-tenant matter. Specifically today, we're going to cover what you should avoid in order so that you do not pay double for any of the repairs that you make on your rent property. So let me paint a scenario for you. I once represented a landlord who was sued by their tenant because the tenant made repairs on the property and they said, landlord, you need to pay us back for the money we paid in order to repair your property. Now, when the landlord approached me with this case, it seemed pretty cut and dry. The landlord had a written lease, and that written lease required that any repairs be made by the landlord, that the tenant themselves was not authorized in any way to make a repair, and that only the landlord could do it unless the landlord had given written authorization to the tenant to make such a repair. Pretty easy. Again, cut and dry, sweet and simple, easy peasy, should have been a slam dunk win. So we show up to the trial, and naturally my client is there. We've prepared the testimony that we're going to present, and it's going to go a little bit like this. The parties had a residential lease. While the landlord was in fact notified, the tenant did some work. The work was not of good quality, so the landlord responded within a reasonable amount of time, completed the repair, in fact, had to redo the work that the tenant did, and now the place is spick and span. Everything's good. The problem has been resolved. As such, we're not claiming that the tenant should pay for any amount of the repair. We're just saying that the tenant should be denied any ability to recover any of its expenses for this repair. That was our argument. That was our whole case. But the landlord decided he was going to add a few things at trial that we had not discussed during our trial prep. I hope you have enjoyed the video so far. If that is the case, please give us a like. And if you haven't subscribed yet, please consider subscribing. For those of you who are out there who have received unreasonable requests from your tenants for repairs, let me know in the comments below. What is the most unreasonable request you have ever received for a repair from one of your tenants? Let me know in the comments below. I'd love to hear about it. So here's what happened. The tenant began, because the tenant was the plaintiff in this case, they had raised a claim against the landlord. And the tenant talked about what happened on a particular weekend. They said that there was a hole in the roof, and that because of a rainstorm that came that particular Saturday, that water was coming into the unit. They contacted the landlord, and the landlord said, look, unfortunately, I cannot get there until Monday. Go ahead and put a tarp over the roof so that water does not infiltrate the property. I will be there on Monday. The tenant found this unsatisfactory. And so the tenant proceeded, along with a friend of theirs, to go and add shingles onto the roof. The tenant then supplied the landlord with an invoice for a certain amount of money to cover for the work that was performed by both the tenant and the friend. So in our estimation, the invoice probably exceeded the value of the work that was done. The value of the work having been determined not to have been done on a professional level. In fact, the landlord had to go and undo all of it and redo that part of the roof so that in fact the roof was secure enough to withstand a future rain event. Now I believe that just a presentation of that evidence alone would have won the case. Unfortunately, that's not where my client stopped testifying. In fact, my client went on to say the following. Not only did he not trust the quality of the work, but he was not interested in paying for the work of, quote, the illegals that the tenant must have hired to do such a terrible job. Now, when I heard this testimony, I was very quiet. I stood there while my client testified, and while the eyes of the judge grew very large at this testimony. And she proceeded to tell my client that that's not the way she was going to allow anyone to be referred to in her court. Now, immediately my client began to backpedal and say, well, look, I didn't mean any harm, but the harm had been done. I don't think the judge heard anything else we said that day, because it didn't matter when I presented evidence of the lease. It didn't matter when I presented evidence that the tenant had not made a reasonable request. And it didn't matter that my client had a reasonable basis for showing up 2 days later. The judge stopped hearing testimony after my client referred to the people who did the work in the way that he did. So what lesson can we glean from the verdict? Well, the judge said, I'm ruling entirely in favor of the plaintiff, the tenant, landlord. You owe them the full amount that they are seeking. Case closed, gavel pounded. You may leave now. Number one, you really should stick to the script. If you and your attorney are presenting a case, stick to whatever it is you cover. If you're going to come and give new insight, and the first time you plan to present it is at trial, I guarantee you, you're going to have the threat that you're going to say more than you should. And maybe it's not offensive, but maybe it does, shine a light on your actions that the court's going to find negative. At the very least, stick to what you and your attorney have covered. Because if you plan to present it and you don't share that with your attorney, or if you plan to share something that you haven't expressed to your attorney, you haven't given the attorney the opportunity to vet whether or not it's worth mentioning. Too often, we talk about things in a non-legal sense, from a non-legal perspective. But really, the only thing that's important in a legal proceeding are the legally operative facts, not your opinions, not your speculation, not your characterization of a particular person. There was no evidence of the statement that he made. He presumed that this was the legal status of the person who did the work. There was no way to know. We didn't know the actual person because the invoice that we were sent just said such and such. It had the name of the person who did the work, and it had a total. It didn't look like, Joe's Roofing or, Roofers Inc. It looked like some dude got an invoice from Office Depot, hand wrote it, and submitted it to the landlord. So sure, you can guess the immigration status based on that document, but there was no basis for it, and the judge found it offensive. Secondly, know what the law says. In this particular case, the judge found that the emergency situation caused by the water event, the rainstorm, was enough for the landlord to make a good faith effort to show up the day of the storm. However, the landlord wasn't even in town. Now, if we had led with these facts, if we had established that the request for immediate action was simply not possible, that we had made an attempt, that the landlord had tried to get someone there but couldn't because, after all, it was a Saturday and many businesses simply don't operate in this way and don't take phone calls on Saturday, I believe that we otherwise would have won the case. But because we led with this other argument, we were never able to present adequate evidence that the request for immediate action was in and of itself unreasonable. Make sure you know the law and the strategy. If in fact you have an emergency, the court may require that you take some affirmative step and that you're able to prove that you at least made a diligent attempt within reason to respond to a repair. In this case, I believe that we did have evidence of that, but the judge simply was not available for it because of other unfortunate statements. Finally, in a situation like this, be prepared to present evidence to the court that you at least attempted to settle with the plaintiff. Maybe you don't agree entirely with the amount of money that you're being charged. Maybe you don't agree with the quality of the work, but if there is a situation where it appears like the tenant took some reasonable steps, it might cost you less in the long run simply to pay the fee. I'll tell you that the amount of the invoice actually was less than my legal fees. But this landlord was so incensed by the plaintiff, in this case the tenant, even asking for money, that they refused to take a reasonable business position and offer, say, half of it. And say, look, I don't agree entirely with what you're asking, but I'm willing to meet you halfway. Make good and better business decisions by being open to the prospect of settlement. Because remember, there is no such thing as an absolute slam dunk, never lose argument. Every argument can go sideways, especially if you introduce information that the judge finds unacceptable. I hope you have enjoyed today's video. If you have and you haven't given us a like yet, please give us a like. You're going to see a picture of my face close by that you can click on to subscribe to our channel, and a video here that YouTube seems to believe you will enjoy. Until next time though, happy leasing.